to present to you its 4th edition. Ram Jethmalani was a legal luminary in a league completely his own. He has left an indelible mark on the legal, political, and intellectual landscape of India. His is a name synonymous with legal acumen and fearless advocacy, standing as a towering figure in the annals of Indian jurisprudence, yesterday, today, and forever. His contribution beyond the courtroom as a fighter and supporter of fundamental rights and democratic principles enshrined in the Constitution of India have a lasting legacy and will always be having left an imprint on this great nation. As we gather here with the finest legal minds and most distinguished members of India's legal community, Ram Jethmalani's fierce command of the law, his sharp insights into matters of national importance, and his deep principles that were married to the democratic values embedded in the Constitution will guide us through the chosen topic, whether the basic structure doctrine has served India well this evening. We'd like to warmly welcome into our midst our distinguished guests, including our Chief Justice, the Honorable Chief Justice of India, Justice Dr. D.Y. Chandrachud, our guests of honor, the Honorable Union Law Minister, Shri Arjun Ram Meghwal, the Attorney General of India, Mr. R. Venkataramani, the Senior Advocate of the Supreme Court, Mr. Fali Nariman, the former Chief Justice of India, Honorable Justice Mr. Deepak Mishra, one of India's most renowned thought leaders, Mr. S. Gurumurthy, and Senior Advocate Mr. Shyam Diwan. We also like to welcome into our midst Ram Jethmalani's family members, his son, the indomitable senior advocate and leading member of the legal community, Mr. Mahesh Jethmalani, who's been instrumental in taking the incredible legacy of his father forward through this high-profile lecture series. Ladies and gentlemen, Indian democracy is indeed a fascinating and complex system that has evolved over the years, incorporating various values and principles to protect its foundation, enshrined and rooted to the strong principles and doctrines of our Constitution. India's harmonious balance between its pillars has shouldered the vastness and scale of our democracy. Ram Jethmalani has left his imprints on our rich history, inside and outside courtrooms forever, in service to the larger purpose of the nation. We're also joined today by Ram Jethmalani's daughter, his only child, who consciously chose to follow a career in medicine instead of law. After completing medical school at the Grant Medical College in Mumbai, she moved to Detroit, Michigan, with her husband to complete her postgraduate studies in pediatrics. Dr. Shobha Gehani served on the board of directors, chief of pediatrics, and the chief of staff at various times during her tenure with the Comprehensive Services of Detroit in Michigan. She has since retired and continues to live in the US with her children and grandchildren, and I'd like to invite Dr. Shobha Gehani to please say a few words.
I'm honored to be in this position, and with all these distinguished guests, I'm humbled to be in all your presence today. And I have the honor of reading Prime Minister Modi's letter to my beloved brother, Mahesh Jethmalani. And this is his letter. I'm glad to learn about the initiative taken to organize the 4th edition of Ram Jethmalani Memorial Lecture Series. Your endeavor to honor the memory of your father and his abiding contribution to the field of law is commendable. A distinguished figure from the legal fraternity, late Ram Jethmalani possessed profound knowledge of various aspects of law. As a legal practitioner, his skills were truly unparalleled. He has left behind an indelible imprint on our legal landscape. Further, he also had important perspectives on policy. Widely respected by experts and common people, the body of work left behind by him will continue to guide and inspire young minds for years and years to come. The lecture series being organized in his memory, year after year, is growing as a forum for discussion and debate on important issues. I'm sure that this initiative will also provide momentum to the idea of the ease of justice, which is about boosting access to justice, as well as acceleration of justice delivery, which is an important priority for all of us. By combining ease of doing business, ease of living, and ease of justice in this Amrit Kal, we can build a self-reliant, equitable, and just new India. Our legal and judicial system holds a pivotal position in this pursuit. I'm confident that the distinguished speakers in this lecture series and esteemed figures from the legal community will provide valuable insights to align our legal system with the evolving demands of our time, while steadfastly preserving the core principles of justice. Best wishes for the 4th edition of the Ram Jethmalani Memorial Lecture Series from Prime Minister Narendra Modi.
Thank you so much, Dr. Shobha Gehani, for reading the Honorable Prime Minister's message. Ladies and gentlemen, it is but appropriate that we now invite the loving son to one of the most prolific legal minds the country has seen, son to a legal icon who was a genius par excellence, the renowned advocate, Member of Parliament in the Rajya Sabha, Mahesh Jethmalani. Mr. Jethmalani continues the legacy of his father both at the bar and beyond. And as an accomplished senior advocate, Mr. Jethmalani is well known for his unmatched prowess inside the courtrooms, as he is in raising his voice outside it on issues pertaining to the country and the protection of its constitutional rights. It is my proud privilege to invite now Mr. Mahesh Jethmalani to formally open this much-awaited event and welcome all our friends and guests.
Honorable Chief Justice of India, Dr. D.Y. Chandrachud, Honorable Law Minister, Shri Arjun Ram Meghwal, Honorable Attorney General, Shri R. Venkatramani, keynote speakers, Shri Fali Nariman, retired Chief Justice Deepak Mishra, Shri Gurumurthy, and Shri Sham Diwan, ladies and gentlemen. It is with immense pride that I welcome you all to the 4th edition, which is the Centenary edition, of the Ram Jethmalani Memorial Lecture. The lecture series was first launched in 2020, and in virtue of COVID and its aftermath, it was conducted virtually. This is the first physical event, which is also being broadcast virtually, and I pray that this hybrid format persists for all times to come. It is a measure of the success and popularity of the lecture series that in addition to Republic TV and NewsX, who broadcast this event last year, this year the series is being covered live by a large number of prominent sections of the print, electronic, and digital media live. I extend my heartfelt gratitude to all of them. This year, we are honored to have as chief guest the present Chief Justice of India, Honorable Shri Dr. Chandrachud. His concurrence to preside as chief guest at today's event would have particularly warmed my father's heart. Not only because of the eminence of his office and his erudition as a jurist, but more so because post-partition, after he joined the bar, Dr. Chandrachud's parents were amongst the earliest and closest friends of my parents, a friendship that endured till the very end. I warmly welcome as well the Honorable Law Minister, Shri Arjun Ram Meghwal, and the Honorable Attorney General, Shri R. Venkatramani, for taking time out of their busy schedules and agreeing to participate as guests of honor at this event. I also welcome and thank profusely every one of our 4 keynote speakers on the topic of today's discussion. The panel of keynote speakers has been very carefully curated. All of them, through their actions, speeches, judgments, arguments, have been passionate crusaders for our constitutional rights and have done their utmost to ensure that the flame of liberty in this country burns brightly. Their expertise on the topic of today's discussion is renowned. While my friend, old friend, or friend of old, I would say, Mr. Gurumurthy, is not a jurist, he was part of what, in 1975, was called the Indian Express Group, which under the legendary newspaper baron, the late Ramnath Goenka, and my late father, fearlessly battled the declaration of emergency. He has lived and suffered the subversion of Article 19, and his experience has given him a deep insight into the Constitution and the pros and cons of the basic structure doctrine in particular. Finally, a word about today's topic of discussion. Throughout his career, both legal and political, my late father had many glorious moments, and of course, to be objective, some eminently forgettable ones as well. But all things considered, if I had to pick his finest hour, his absolutely best hour, it would be the relentless and magnificent battle he fought both inside and outside the courts at great personal risk during the emergency. Liberty was his compelling and enduring passion, and he was eternally vigilant about it, about protecting it. Today's topic is designed to determine how future generations can best secure their freedoms. The basic structure doctrine stares us in the face. It once failed us. This judicially fashioned core feature of our Constitution is too layman, esoteric, and enigmatic. I hope that today's discussion enlightens us about the meaning, scope, limits, and most of all, the viability of the doctrine of the basic features as the anchor of our fundamental rights. Thank you, ladies and gentlemen.
Ladies and gentlemen, the Honorable Chief Justice of India, Justice Dr. D.Y. Chandrachud.
The family of Mr. Ram Jethmalani, who is assembled here from near and far, Mr. Arjun Ram Meghwal, the Union Minister for Law and Justice, Mr. R. Venkatramani, the Attorney General for India, my very distinguished Chief Justice, Justice Deepak Mishra, Mr. Fali Nariman, Mr. Shyam Diwan, Mr. S. Gurumurthy, members of the bar, and everyone present here. I'm quite overwhelmed, honestly, to be speaking about Ram Jethmalani, whose legacy continues to resonate in the hearts and minds of people across India. Yesterday was his 100th birth anniversary. It is not every day of our lives that we get the opportunity to celebrate the legacy of such great human beings. And honestly, I thought I should say a few words about him. Because for the younger generation, many of whom have not witnessed the years that we have to ask ourselves, how do you clone a Ram Jethmalani? And can we really clone Ram Jethmalani? Possibly no, because to clone Ram Jethmalani, we'll have to clone the social and the historic and the political times in which he grew and flourished and evolved as a human being. He donned many robes. He was India's top criminal lawyer, unquestionably so. He was an acclaimed parliamentarian, elected as a member of the Lok Sabha twice and of the Rajya Sabha once. Ram's legacy endures not only because of his unparalleled mastery over the law, but also due to his relentless pursuit for justice through legal and constitutional means. He lived in times when one could be despondent about the way in which things were turning out after independence. But he never gave up his pursuit, his faith, his belief in the Constitution, in the law, as a means of bringing out orderly change. He was, in that sense, a luminary who left a profound and lasting contribution to the rule of law. Ram Jethmalani's first case was before the Sindh High Court. At the young age of 17, the enrollment rule prescribed a minimum age of 21 years, which prevented Ram Jethmalani from starting his legal career at the age of 17. Ram argued his own case before the Chief Justice of the Sindh High Court when he was a student of law, challenging the minimum criterion prescribed by the rule. He passionately argued before Sir Godfrey Davis that his parents would not have permitted him to study law if they knew that he would not be able to support the family for 4 years after graduating, in a sense. It was an argument of legitimate expectations, as we would have perhaps learned to call it several years thereafter. Ram clothed this argument of legitimate expectation with an emotional undertone, and it worked in his favor. Sir Godfrey, who was swayed by Jethmalani's persuasive skills, asked the Bar Council to amend the rules to introduce an exception. The colonial masters in those days didn't feel constrained by what we feel, namely the limitations on our jurisdiction to issue a mandamus to the legislature or to a subordinate to amend the law. It was right at that time, at a young age of 17, that both Ram and those around him realized that he was going to be a formidable force in the legal fraternity and who had the ability to take the courts by a storm. This early display of determination and commitment set the stage for a lifelong pursuit of justice. He came to Bombay, as it was then called, with all but rupees 10. As a refugee, he understood the plight of those at the fringes, especially the partition refugees. Just 3 years into his practice at Bombay, Ram Jethmalani made his first impression as a constitutional lawyer. He argued a challenge in the Bombay High Court to the Bombay Refugee Act of 1947, which granted extensive powers to the state government to confine refugees. Ram deemed it an affront to their dignity and passionately argued against its constitutionality. It was the first case that he argued after he enrolled as an advocate and went on to win it. Despite the recent adoption of the Constitution and a lack of guiding case precedent, he successfully argued that the legislature did not have the competence to enact such an excessive law. And he sowed the seeds of proportionality in his argument. He went on to appear before the Supreme Court in 1957, just 10 years after he started his practice in Mumbai. Even in his initial years of practice, he carved a reputation for himself as a brilliant criminal lawyer. In 1959, Ram was involved in the prosecution of K.M. Nanavati, Commander K.M. Nanavati. Commander Nanavati was an officer in the Indian Navy, handsome at that, who had settled down in Bombay with his English-born wife and their children. With Nanavati being away from home on long assignments at sea, Sylvia found companionship with Nanavati's friend Prem Ahuja. Sylvia confessed about her affair to Nanavati on his return from his assignment. Enraged by the confession, Nanavati went to the naval base to collect his pistol and then went to confront Ahuja. According to Nanavati's account, he had asked if Ahuja would marry Sylvia and accept their children. On hearing a negative response, he fired 3 bullets, and not unexpectedly, Ahuja just dropped dead. The case was tried by the jury, the last case that we ever tried by a jury in India. The issue before the jury was whether Nanavati shot the victim in the heat of the moment, or whether it was premeditated murder. Ram was hired as a watching counsel by the sister of the victim. His role was to protect the victim and help with the prosecution strategy. There was a great Chari who was appearing in that case. The public prosecutor followed the line of questioning developed by Ram, and theatrical it was. He asked the surgeon on the stand why the victim would start the alleged fight without his glasses on, and how the 2 protagonists could have got into such a scuffle that the gun would go off accidentally with a towel wrapped around the waist of Prem Ahuja undisturbed. The case was sensationalized, and the jury was overawed with emotions for Nanavati and handed him an acquittal. However, if the judge wanted to send the case to the High Court for reconsideration, they had to prove that the jury was under wrong instructions. A decision of the jury could be overturned on very limited grounds. It was Ram Jethmalani who wrote the brief for the prosecution lawyer, then Mr. Y.V. Chandrachud, pointing out 8 instances of jury misdirection. The argument of jury misdirection was accepted. When the case was heard by the High Court, it found merit in the arguments of the prosecution and convicted Nanavati. But there's a story, there's a sting in the tail which Ram himself told me about. He said when the case opened, the entire court was hostile to the government pleader, namely Justice Chandrachud, who was then arguing the case. He says on the last day after the conviction had been rendered, Justice Shelat turned to the government pleader and said, Mr. Chandrachud, so are you pressing for death? Virtually indicating that if you argue for death, this was a case for the imposition of the death penalty. And we didn't have Bachchan Singh in those days, mind you. And the public prosecutor got up and said, my lords, I've got the conviction, but this is not a case for the award of the death penalty. And eventually, he was sentenced to imprisonment for life. The appeal against the conviction was also dismissed by the Supreme Court, but he got a pardon thereafter. There really began the friendship between my own parents and Ram and Ratna, which continued almost to the last day of their lives. Ram had the wit and vigor to work within the minute gaps and the gray areas of law. That is what set him apart from the rest of them. As a criminal lawyer, he was known for his art of cross-examination, bravado, and wit. He approached his cases with an investigative lens, an important craft for every criminal lawyer. He would ask for plausible explanations and give an astute psychological analysis of what a person normally would or would not do. Ram had that innate ability in him, which only the best of the criminal lawyers have, of recreating a crime scene. In 1988, he was appointed as amicus curiae to defend the person accused of assassinating Prime Minister Indira Gandhi. The trial court had convicted 3 persons for the assassination and sentenced them to death. The High Court of Delhi confirmed the death sentence. At the Supreme Court, as amicus curiae, persuaded by Ram Jethmalani's argument, a 3-judge bench unanimously not only set aside the death penalty, but also reversed the conviction of one of the accused, namely Balbir Singh. He would call this case one of his best forensic successes. The prosecution evidence relied upon a piece of paper supposedly found in the pocket of the accused with cryptic dates and names. Ram argued on the obvious foolishness of any person in carrying incriminating evidence after a month of the crime, when public opinion was so heavily against the perpetrators. Ram gave it his all to prevent the execution of the other two accused persons as well. On the counsel of Jethmalani, the accused had petitioned the President under Article 72 of the Constitution to grant pardon, which was rejected. News broke out that the two men convicted of assassinating Indira Gandhi were to be hanged at 8 p.m. the next day. However, the hanging was stayed by the Supreme Court just 14 hours before the planned execution, because Jethmalani had raised a constitutional question over the President's refusal to grant him a hearing. He argued that the pardoning power of the President cannot be exercised arbitrarily, and that there must be guidelines for the exercise of this power, because, as he remarked, secret guidelines, he said, are no guidelines. Though he was able to secure a short-term stay of the execution, he was unable to get it set aside. A month later, both the accused were hanged, but Ram's contribution should not be downplayed. He raised seminal constitutional questions in the course of the hearing, which went on to change the legal landscape on the death penalty. He couldn't protect his two clients from execution, but he protected the Constitution and the way it has evolved and as we know it today. I would even consider this case as one of the cases which sparked the extensive debate on death sentence in India. Ram Jethmalani was not only a formidable advocate, but also a passionate teacher. He started teaching at the Government Law College in Mumbai in 1953, an accomplishment that was no small feat for a person with no prior connections in the city. His eloquence, meticulous preparation, and deep knowledge made him one of the most sought-after teachers. He went on to play a pivotal role in the setting up of the National Law School of India University at Bangalore. Ram was beautifully networked. Whom did he not know in the political or legal scene? But he used his network for social purpose. He was a great friend of Ramakrishna Hegde, the Chief Minister of Karnataka, but he persuaded Hegde to give land for the Bar Council of India's National Law School of India University. In fact, he also went on to teach a course on the law of evidence at NLSIU for a term. His contributions led to the formulation of the 5-year integrated law program, an independent entrance examination for law schools, academic autonomy, and better quality education for students with a holistic curriculum. Ram Jethmalani would say that he would like to be remembered as a good teacher who could make a difference to the lives of the young. And difference he made. His teachings inside and outside classrooms, both at National Law School and at Symbiosis in Pune, which he was deeply fond of, continue to guide his students, his juniors, and even the judges, like me, who had the pleasure of hearing his succinct legal arguments. Ram, in that sense, democratized access to the legal profession. By setting up these law schools, legal education ceased to be the prerogative of those who are socially advanced or economically resourced. Legal education opened up for people without backgrounds, without family connections, without social capital, without cultural capital. Ram's unflinching sense of courage must also be remembered and celebrated. When the emergency was imposed in the 1970s, and when the civil liberties of persons were put on a hold, speech was censured, and arrest warrants were issued carelessly and callously against political opponents. Ashok Mahadevan, a young journalist of 26 years old, protested against the suppression of speech by publishing a 22-word obituary in the Times of India. One thing which I learned as a child was to devour the newspapers. And I still remember this obituary, which I must share with particularly the younger people here in the audience. And the obituary on the 26th of June, 1975 read as follows. Hear it carefully. O apostrophe crazy, D-E-M, beloved husband of T. Ruth, loving father of L.I. Bertie, brother of faith, hope, and Justicia, expired on June 26. The young journalist, with the use of smart wordplay, protested against the emergency. The obituary actually meant that democracy, the loving husband of truth, loving father of liberty, brother of faith, hope and justice, expired on June 26. That is the day the emergency was declared. The legal community on many fronts, both inside and outside the courts, led the struggle to restore the rule of law. And Ram was at the forefront. He was the chairperson of the Bar Council of India during the emergency and was very vocal about his opposition to the emergency. In 1976, he spoke fervently against the imposition of the emergency and the curtailment of liberties while he had gone to attend the All Kerala Lawyers Conference in Palghat. Even before he could travel back to Mumbai, an arrest warrant was issued against him under the provisions of the Maintenance of Internal Security Act. No less than 300 lawyers, led by Nani Palkhiwala, went to the Bombay High Court to secure a stay of the arrest warrant. But the stay was good only till the Supreme Court pronounced its verdict in ADM Jabalpur versus Shivkant Shukla. While arguing the ADM Jabalpur case, Ram memorably reminded the judges that erosion of civil liberties spares no one in its wrath, not even the courts. Ram began his arguments before the Supreme Court by saying, "My lords," he said, "you will not be impressed by the fact that I am appearing for one detenue. Now I am going to tell you that I am appearing for all 5 of you." Like the outcome of this case, he witnessed many firsts and the lasts in the legal landscape, but his heart lay in strengthening democratic institutions. He never despaired by outcomes which were contrary to what he argued as a stated legal position. In that sense, he didn't have the ego of a person who believes he is morally right in everything that he argues, because he knew that he was arguing for a perspective which he believed in. During his legal career, which spanned over decades, Ram argued as a defense lawyer in a lot of high-profile cases, such as the Harshad Mehta market scams case, which, by the way, was fortunately the case which led the lawyers' fees to go out of the roof. The Hawala scam, the accused in the Jessica Lal murder case. When he was asked if he appeared for a lot of high-profile cases because it paid him well, he replied, "Of course, naturally," he said. He also went on to say that a lawyer who refuses to defend a person on the ground that people believe him to be guilty is himself guilty of professional misconduct. But Ram also understood that access to justice would be an illusion if lawyers charge exorbitant professional fees or appearances. He recognized the deep inequalities which plagued the society and was deeply concerned about the injustices meted out to the common citizen. By some estimates, he charged only 10% of his clients, and 90% of the cases were handled by him pro bono. I've actually witnessed him in the bar library of the Supreme Court Bar Association, quoting a fee virtually at the back of his hat, or the top of his hat, and asking for a fee of the unstatable. He also recognized that institutional reforms are required to enhance the quality of justice and access to justice. He once said that only perceptive practitioners sitting in court notice the frequent miscarriage of justice. Correction does not require legislation. Setting up traditions binding on the Chief Justice of the court is enough. So I thought I'd end the first part of my presentation by reminding myself that you do not require a change in legislation. Setting up traditions binding on the Chief Justice of the court is enough. Ram was an amazing mentor. I'll just give you 2 little examples and I'll then go to the more formal part, and I hope not to bore you beyond that. We were doing a high-profile case and we were appearing for the chairman and managing director of a not-to-be-mentioned corporate group in India. In the Bombay High Court, an excise circular was placed before the court, and it so happened that the circular was fabricated. The judge in the Bombay High Court decided to initiate proceedings under Section 195 and 340 of the CRPC, and we came in appeal to the Supreme Court. And we were against one of the most hostile benches that you could imagine. And it made it worse for us because we thought that both the judges had a slightly pro-revenue stance in their ideology. The first part of the session, the morning session, Ram was subject to a hostile bench. We went back to his chamber for lunch, and we were extremely worried about what the outcome was going to be. So we asked Ram, well, what are we going to do after lunch? So he looked at me and said, for starters, we need to get some chicken patties from Wenger's. So order we did for some chicken patties from Wenger's. I don't know whether it was the patties or what happened, but after lunch, it was just sheer brilliance. Brilliance personified. In about 20 minutes, we had the judges completely turned. And one of the most hostile benches came and said, well, we are allowing the appeal. As Ram evolved in life, many of his lesser-known clients had to go to the lesser-known lawyers because he was no longer fit enough to appear for them. And that's how people like me who were fledglings at the bar picked up the work. He introduced me to the Indian Express work. There were remnants of the work which had remained, the Customs Act cases of the emergency which were still lingering on in the 1980s. And that got me an opportunity to go to Express Towers with Ram's juniors and to prepare pleadings. Criminal appeals. It was a sheer joy to sit with him even while drafting a special leave petition. I remember a case where there were about 14 accused, and he gave me a brief sitting of about 10 minutes to explain to me how a criminal appeal should be drafted, how you must analyze the role of every accused, who were the eyewitnesses, what was the specific act, the overt act which was attributed to the accused. The topic of the day, of course, which Mr. Mahesh Jethmalani has thought everybody should open up with, is about the basic structure doctrine. Much as I admire Mr. Ram Jethmalani, one thing I wouldn't like to share with him is his ability to court controversy. So I thought that if I have to do something about this doctrine, I should do it through my judgments and not in an off-the-court pronouncement. So I've taken Mahesh's permission to talk about something a little different. And that's just about 5 or 7 minutes. The Supreme Court, which all of you probably don't know about. And let me tell you a little bit about the Supreme Court you don't know about, because you read about the Supreme Court in the electronic media, social media, they're trolling us every day, the print media, and of course the law reports. But let me tell you about the court which I would like to tell you about. The COVID-19 pandemic had just started receding when I took over as Chief Justice of India. I was aware of the huge responsibility which I would be shouldering. The pendency rates had increased because of the pandemic. Most of us had lost somebody dear. The pandemic had not only brought the world to a standstill, but also left emotional scars from which we are yet to recover. While I knew that I had to prioritize speedy disposals, I also knew that I had to prioritize the mental health of lawyers and registry officials by not pushing them to overwork themselves both physically and mentally. They are not poster persons of the justice delivery system, but they are certainly at the forefront, keeping the cart moving one day at a time. It is important that their efforts are recognized. My first goal as the Chief Justice of India has been to institutionalize the courts and move away from an ad hoc model of operation. Too often the problems with our institutions are that every individual who comes into the institution lays down innovative ideas, only for those ideas to be forgotten after each of us passes on the baton to the next person. One of the important effects of institutionalizing courts is that it enhances transparency and accountability. While these are very important effects of institutionalization, we should also not forget the human side of the story. I have, in the course of my 10 months as the Chief Justice, realized that institutionalization, in addition to enhancing transparency, also humanizes the workspace. The staff are able to draw boundaries between work and home and increase their work efficiency. It has also positively changed things on those on the other side, that is the bar. We have implemented filing of cases in the electronic form, removal of defects, submission of urgent listings, and appearance slips, all through online portals in the Supreme Court. It's way more easier now to file pleadings than to live in the anxiety of standing in lines, waiting for a person to mark defects in the file and returning it to be filed afresh. Citizens can now also find out the status of their cases instead of having to rely on their advocates, who, because of their busy schedules, may not always relay the update. Of course, this is a change, and changes don't come easy, but it is a change worth making for enhancement of the justice delivery system. At this point, it is necessary to emphasize that when I speak about enhancement, I do not limit the reference to quality judgments. My focus is also on reducing barriers to accessing the courts, easing the process of filing and arguing before the court. My focus is on improving the gender ratio of lawyers. My focus is on ensuring that lawyers and litigants have facilities to comfortably rest while at court. It is only with such an holistic approach that the quality of justice delivery could be enhanced in every sense of the word. The Supreme Court is bursting at its seams. Our building was constructed in 1950, and we have moved the government with a blueprint of a new building to replace one of our older buildings which were constructed in the late 1980s or 90s, and to have a modern Supreme Court building in the same complex with 27 courtrooms, bar association spaces for the women lawyers, for the Supreme Court Bar Association, for the advocates on record, and above all, for our litigants. One of the primary requirements for institutionalizing the court system is to identify the issues that hamper our efficiency and curating remedies to address such issues. An able team of judges, lawyers, and researchers working at the Center for Research and Planning are assisting the courts with this work. Their work is invaluable, particularly because of the lack of research and data on the functioning of courts in India. The Center for Research and Planning is now in the process of creating a system for managing and reducing the case pendency through a project called SC Judicare, which stands for Judicial Disposal through Case Management and Resource Efficiency. The project aims to increase efficiency through improved case classification, grouping, and tagging. Phase 1 of the project is underway, where we have collected data on pending dockets to frame guidelines. We have also prepared a roadmap for auditing criminal matters. Our aim is to integrate granular data with integrated case management information systems, identify infructuous matters, and devise strategic priorities at an institutional level. Let me also deal with one of the criticisms which I hear, and I look at criticisms in a very positive and optimistic perspective. Because if you look at criticism cynically, you can never improve your institution for the better. One of the criticisms which is expressed about the collegium is that we have no factual data to evaluate people who we are considering for appointment to the Supreme Court. I just wanted to share with you some of the steps which we have taken. It's still work in progress, but we are improving. I have a Center for Research and Planning. The Center for Research and Planning is headed by an officer from the Haryana Judicial Service with two very distinguished young scholars and a number of young people, interns, law researchers who come and work with us for 2 years. We have prepared a dossier. I shouldn't call it a dossier, but we have prepared a broad platform where we have assessed every one of the top 50 judges in the country who would be considered for appointment as judges of the Supreme Court. We have data on judgments. We have data on reportable judgments. We have data on the quality of judgments which judges are delivering. The idea is to make the process of recommending appointments to the Supreme Court more transparent. Not transparent in terms of sharing our discussions in the public realm. You can't obviously do that. But by laying down objective parameters for selection both to the high courts and to the Supreme Court. Yesterday, the Supreme Court got on board the National Judicial Data Grid, which would provide real-time tracking of disposal and pendency with a click. This will increase inter-court coordination of data and aid in conducting quality research. Disposal and pendency of the Supreme Court is now available case-wise, year-wise, stage-wise, and quorum-wise. This information will help the court to identify areas of concern to decrease pendency. Institutionalization requires policy solutions. Due to the lack of data, it has been painfully difficult to devise methods to reduce pendency. Now, we know according to the NJDG data, there are 62,946 pending civil cases and 17,555 pending criminal cases. We also know that 15,000 cases have not been registered as yet, which means that the lawyers have still to get these cases ready for hearing. So the actual pendency is in the vicinity of 65,000, with 15,000 cases not really in that stage of being pending judicial cases. We have had a disposal rate of 95.34% this year. Our court has disposed of 95% of the cases which have been instituted this year. This data will help me prioritize certain categories of matters, such as the oldest pending cases, for their able disposal, and would allow us to introspect our performance in terms of disposal throughout the year. Another significant step that we have taken is to make the Supreme Court and High Court judgments available through the eSCR portal. When I started litigating way back in the 80s in the Bombay High Court, we used to get the All India Reporter or the Supreme Court report volumes upon subscribing to their print editions. We would wait to see the latest development in law and would be so thrilled to find a senior's office or a court library with an up-to-date record. In our common law system, court precedents are a vital source of law. Now there are online databases available, and the printed AIR and SCC records have become decorative books in law chambers. However, many young lawyers and law students find it difficult to subscribe to online databases because of the high price. This creates a professional barrier for young graduates, particularly from those from marginalized communities, such as the scheduled castes and the scheduled tribes. But the difference between my days of legal practice and lawyers starting out today is that dissemination of information is no longer priced. What was once impossible is now a reality. More than 36,016 Supreme Court and 11.6 million High Court judgments are available on the eSCR portal and the free text search portal of the E-Committee of the Supreme Court. The portal allows free text search of judgments by providing a combination of various search options and keywords. The embedded filtering feature allows further filtering on available results. The eSCR project was devised with the aim of providing free access to judgments so that a person's financial standing or institutional affiliation does not unfairly restrict them. In that, we must think of Ram when he came back from Sindh, and not Ram as that very highly resourced, extremely brilliant lawyer at the top of the career. We cannot pretend that these issues do not exist. The eSCR portal is a challenge to the mindset that one requires financial standing to make quality arguments. I implore all the lawyers here to start using the search portal. If any of you have ideas to better the services provided by eSCR, kindly reach out to my office. We are now also moving to a paperless mode of pleadings and communication. Courtrooms of the Supreme Court are becoming tech-friendly. In courtrooms 1 to 3 of the Supreme Court, the law books that once marked the perimeter of the room are replaced with e-libraries. Digital display systems have been installed for judges and advocates. In the constitutional bench hearing on the challenge to the abrogation of Article 370 that concluded recently, we saw a record of 47,835 pages of paper book, case documents, case law, compilations, and written submissions of the petitioners and respondents. All of them were scanned and digitized to allow a paperless bench and a largely paperless bar. I like to practice what I preach. In my office, all communications for approval with the registry, even internal notes take through the paperless mode, through e-office. When I took over as the Chief Justice, I realized the sheer frequency and volume of approval that is required for every decision taken by the court staff and the registry, including the flowers that are put in the foyer of the Supreme Court. Each time the staff would come to me with a stack of papers to peruse only for a signature, I took a call and asked the staff and the registry to send over e-documents, which are now e-signed by me. I'm not sure how Ram Jethmalani would have reacted to these reforms. But I thought I should mention this because I know that he is sitting up above the twinkling stars, he and Ratna, with my own parents, Yashwant and Prabha. True to his maverick pedigree, he would have given further suggestions for improving court's efficiency and reducing case backlog. He touched us with the genuine concern he shared for the systems he inhabited. A fitting tribute to a person like Ram is that we too continue to be concerned and be a part of change in the systems we inhabit. The way I see it, he was not just concerned about what he found, he was more interested in whether he left it better than he found it. It has been a great honor reminiscing the legacy of Ram Jethmalani, one of the greatest of our times. Thank you very much.
Thank you very much, sir, for your words of immense value. We are indebted to you for having been with us despite your incredibly demanding and tight schedule. Thank you very much, sir, for having been with us. As the Honorable Chief Justice takes leave, I request Mr. Mahesh Jethmalani to please escort him and see him off. Please be seated, ladies and gentlemen. We will continue with our program. I'd like to now introduce our guest of honor this evening, the Honorable Union Minister for Law and Justice, Shri Arjun Ram Meghwal. The Honorable Minister steers the ship on the side of the executive to ensure that democratic principles and the principle of law are upheld in consonance with our enshrined constitutional values and vision. He plays a pivotal role in shaping the legal landscape, ensuring that our nation's laws and justice system reflect the values and aspirations of our diverse society. May I invite the Honorable Union Minister for Law and Justice, Shri Arjun Ram Meghwal, to please deliver the keynote address.
राम जेठमलानी जी की याद में जो आज मेमोरियल लेक्चर रखा है, इसमें बहुत सी बातें हमारे चीफ जस्टिस ऑफ इंडिया जस्टिस ऑनरेबल डी.वाई. चंद्रचूड़ साहब ने बोली और मैंने भी सुनी, आप सब लोगों ने सुनी। उसमें कुछ चीज़ें जोड़ूंगा। मंच पर उपस्थित जस्टिस श्री दीपक मिश्रा जी, Honorable former Chief Justice of India, Sri R. Venkataramani ji, Attorney General of India, Sri S. Nariman ji, S. Gurumurthy ji, श्याम दीवान जी और महेश जेठमलानी जी। देखिए, मैं दो संस्मरण आपको सुनाता हूँ। ऑनरेबल चीफ जस्टिस ऑफ इंडिया चले गए। मुझे लगता है कि ये 2 बार लोकसभा में रहे और 2 बार ही राज्यसभा में रहे, जहाँ तक मुझे ध्यान है। अगर मुझे महेश जी 2 बार रहे राज्यसभा में, 2 बार रहे राज्यसभा में, 2 बार रहे ना राम जेठमलानी जी?
कम से कम 4 बार सर।
हाँ, तो ऐसे वो कमी हो गई। वो 1 बार का बहुत, कितनी बार रहे? 4 बार।
4 बार।
लोकसभा कितनी बार रहे?
2 बार।
2 बार ना, तो राज्यसभा तो बहुत रहे, इसका मतलब। नहीं, ठीक है, ठीक है। मैं एक किस्सा सुनाता हूँ 2013 का आपको। आप तो थे नहीं महेश जी शायद घर पे। वो राजस्थान से राज्यसभा के मेंबर थे, आपको अगर गलत नहीं हो तो हम एक ऐसे ही मेमोरियल लेक्चर मेरे बीकानेर में करने का विचार आया और मैं गया उनके पास। मैंने कहा आपको बीकानेर ले जाना है, क्योंकि वो कुछ एक कमेटी थी, उसमें हमारे साथ 1-2 बार आए थे तो उनको लगा ये ठीक है, ऐसा लगा उनको कि आदमी ठीक है, चलिए। तो मैंने कहा बीकानेर चलना है। तो उन्होंने कहा आपको 2 पहले कंडीशन पूरी करनी पड़ेगी। मैंने कहा क्या साहब? मैं घर गया था, शाम का टाइम था। बोला पहले तो आपको मेरे साथ बैडमिंटन खेलना पड़ेगा। तो मैंने कहा बैडमिंटन आप इस उम्र में खेलते हो क्या? तो बोला उम्र कोई बाधा बनती है क्या, बैडमिंटन खेलेंगे। तो मैं इसी ड्रेस में रहता हूं, आमतौर पे मैं इसी ड्रेस में था। मेरे को कहा खेल लोगे क्या? मैंने कहा मैं खेल लूंगा, मैं भी बैडमिंटन का तो शौकीन हूं, खिलाड़ी हूं। तो हमने खेला, 4 प्लेयर थे हमारे, लेकिन उस उम्र में भी इतनी शानदार उन्होंने बैडमिंटन का खेल खेला, जवान भी नहीं खेल सकता। इसके लिए उनको धन्यवाद देना चाहिए, बहुत अच्छा अपना। बट दूसरा मैंने नहीं किया। दूसरी उन्होंने कहा यू हैव टू सिट विथ मी फॉर ए कंपनी। आप लोग समझ गए ना? हाँ, समझ ले तो जोरदार हंस सकते हो। मैंने कहा मैं, बोला ऐसा कैसे हो सकता है, ऐसा संभव ही नहीं है। मैंने कहा इसमें मैं आपके साथ बैठ जाऊंगा, अगर कुछ चीज खाने की आएगी तो खाऊंगा। लेकिन ये दोनों एक्सपीरियंस में करीब घंटा 1.5 घंटा रहा उनके घर, दोनों बहुत शानदार एक्सपीरियंस। और मुझे लगा कि इतने शानदार इंसान, जानदार और शानदार, नॉलेज का तो कोई शान ही नहीं था उनका, वो तो एक अलग विषय है, लेकिन बहुत ही शानदार और जानदार इंसान। उनके लिए आपने लेक्चर्स, मेमोरियल लेक्चर रखा। बेसिक स्ट्रक्चर के बारे में बाकी लोग बताएंगे, अभी मैंने देखा वो ऑनरेबल चीफ जस्टिस ऑफ इंडिया बताएंगे, लेकिन उन्होंने बाकियों के लिए छोड़ा, मुझे ऐसा लगता है। लेकिन मेरे को उन्होंने कहा कि श्याम का मेरा बेसिक स्ट्रक्चर है खेलना, दूसरा बेसिक स्ट्रक्चर है बैठना। बहुत शानदार इंसान। मेरे को अभी नानावटी केस के बारे में, जब हम पढ़ते थे कॉलेज में, लॉ का स्टूडेंट होने के नाते, ये आज उन्होंने जो ऑनरेबल चीफ जस्टिस ऑफ इंडिया साहब ने समझाया केस, उस समय भी समझाते थे, क्या शानदार केस में। लेकिन कहाँ सिंध से प्रैक्टिस शुरू की, नानावटी केस में भी फेमस हुए, इमरजेंसी में भी फेमस हुए, श्री राम मंदिर वाले मामले में भी फेमस हुए, अडवाणी जी के केस में भी फेमस हुए, मोदी जी के केस में भी फेमस हुए, लालू जी के केस में भी फेमस हुए। कौन सा केस है तो उन्होंने छोड़ा, और हर केस में फेमस हुए। जबरदस्त उन्होंने इस देश को दिशा दिखाई। और मुझे तो गर्व ये होता है महेश जी, कि जिस जगह मैं आज बैठता हूं उस कुर्सी पे भी राम जेठमलानी बैठे हुए थे, लॉ मिनिस्टर भी थे वो। तो ये मेरे लिए तो बहुत गर्व की बात है। बलबीर जी पुन साहब आए थे तो मैं ये कहने वाला था कि आपका आर्टिकल एक मैंने पढ़ा, शानदार। अच्छा, मुकुल जी भी बैठे हैं क्या? धन्यवाद आपको। तो ये इतने शानदार इंसान जिनकी याद में अब रामनाथ गोविंद का क्या इशू आया, इमरजेंसी का भी इशू आया, कितने ही उनके मेमोरीज होंगी जिसके बारे में आप चर्चा कर सकते हैं। मैं सुप्रीम कोर्ट ऑफ इंडिया को एक धन्यवाद देना चाहूँगा। जस्टिस डी वाई चंद्रचूड़ साहब चले गए हैं। देखिए, मैं एक बार कोई एडीआर के इशू में अभी लंदन गया था, तो वहाँ एक विषय आया कि वीसी के थ्रू, वीडियो कॉन्फ्रेंसिंग के थ्रू सबसे ज़्यादा किसी सुप्रीम कोर्ट में सुनवाई हुई, केस सेटल हुए तो इंडिया। तो मुझे भी अच्छा लगा। ये मैं कम्युनिकेट कर दूंगा कि मैं आपके पीछे से बोला हूँ, अब आप भी कम्युनिकेट करना उनको, और मैं भी कम्युनिकेट करूंगा कि बहुत बहुत तरीके से उन्होंने कहा। और मुझे लगता है टेक्नोलॉजी का यूज करने के लिए जिसका जिक्र आज इस मंच से हमारे चीफ जस्टिस ऑफ इंडिया कर रहे थे, वो है नेशनल जुडिशियल डेटा ग्रिड, और जिसका कल इन्होंने ट्वीट किया, फिर प्रधानमंत्री श्री नरेंद्र मोदी जी ने उसी ट्वीट को ट्वीट किया। तो आज मीडिया में बड़ी खबर है कि इस तरह के जो चेंजेस भारत में आ रहे हैं, वो हमारे जो पेंडेंसी है केसेस की, उसमें कमी लाने में भी मदद करेंगे, नागरिकों का जीवन भी आसान करेंगे। कौन सा केस चल रहा है, क्या डेट है, कौन से बेंच में आएगा, ये सब चीज़ें आपको ऑनलाइन उपलब्ध रहेगी। मैं इस अवसर पर, चूंकि बाकी सभी मेहमानों को बोलना है और मुझे जो टाइम निर्धारित किया है उस नहीं, इसमें है लिखा हुआ इसमें है लिखा हुआ तो वही मान लेते हैं अपन जो लिखा हुआ है। बाकियों को सुनूंगा मैं, क्योंकि मैं लर्नर हूं, ज़्यादा सुनने में विश्वास रखता हूं। लेकिन आप सब आए, आप सब लोग आए, आप सबको भी शुभकामना, बधाई। देखिए, कोई आदमी जाने के बाद याद ज़्यादा क्यों किया जाता है? तो एक कवि ने बहुत ठीक कहा है, जाना तो सबको है ना, समझ लो कि मृत्यु है ना, मृत्यु से डरो कभी, मरो परंतु यों मरो की याद जो करें सभी। बहुत बहुत धन्यवाद।
Thank you very much, sir, for your words of wisdom. Ladies and gentlemen, at this moment we'd like to request two gentlemen to please join us up on stage. The Chairman and Editor-in-Chief, Republic Media Network, Mr. Arnab Goswami, and the founder of ITV and Rajya Sabha MP, Mr. Kartikeya Sharma, to please come up as well. Thank you very much. Ladies and gentlemen, we have in our midst a legal stalwart who occupies a position of utmost significance within our nation's legal framework, the Attorney General of India, Mr. R. Venkataramani, with over 4 decades of splendid active practice at the Supreme Court. He is one of India's finest jurists, deeply committed to constitutional issues as well as to building India's future legal eagles. As the Attorney General of India, Mr. R. Venkataramani is the custodian of the Constitution, a defender of individual rights, a guardian of the principles that underpin our great nation. Please join me in inviting the guest of honor, the Attorney General of India, Mr. R. Venkataramani, to address the gathering.
Thank you, my dear. What I recall the words of Justice Krishna here, comrades and friends, as they call it, in his bright, emotional. So, Comrade Mahesh Jethmalani, thank you for inviting me to here today. Why I use the word, I'll tell you a little later. I brought my prepared speech, and I think I'm leaving it on my table. Much of it has been stolen by Chief Justice of India. But I thought Chief Justice always very passionate about justice. His engagement of his mind in varied dimensions of doing justice is remarkable. But today I found something more rare, a rare passion today. Maybe Mr. Jethmalani was standing by his side and telling him that we have a long association with me and my family is something which is, we use something called ineradicable. That rare passion, something very interesting today. I found it so exciting that when I left my prepared speech, which would have probably talked about what cases Mr. Jethmalani argued and so on and so forth, let me only say a few statements. I mean, the minister is here, and I'm sure that you would agree with the Attorney General for making such probably radical statements, bold statements about what the Constitution should do in our country and what good governance should be talking about. So I would probably say that in honor of Mr. Jethmalani, if we have built a grand temple in honor of Lord Ram in Ayodhya, probably we need to build institutional temples in honor of Ram Jethmalani. I have in mind a few institutional temples. One is if history of liberty in this country will be ever written, I say Ram had his mind always what Justice Learned Hand said, liberty lies in the hearts of men. So if ever history had to be written in our country, the way it is being written in some parts of the world, I pass here for a minute to say that unlike what is being written in America or in Europe about the contribution of eminent persons in the legal fraternity to growth of law and justice has not been well attempted here in our country. We need to probably engage in a genre of literature. Women in the legal fraternity have been preeminently and fundamentally responsible for certain entrenchment of certain doctrines as part of our law and legal system. So therefore, I would like to say that let us begin to chronicle the contributions of such eminent persons in the legal fraternity who have made the trajectory of law and justice in our country very, very different from what we thought it would be like to be in 1950. So my first contribution would be to ask those of you here, probably Mahesh should have thought about a bigger auditorium where more and more willing minds and inclined minds would be part of a contribution, both in writing and otherwise, would have been here. I invite each and every one of you who would like to be part of this engagement to write about such eminent persons as an integral part of the graph of Indian constitutional history and justice administration. The second I would like to probably invite is, as I took over, of course, if the Attorney General cannot think on his feet, what else he is fit for? So as I took over, I thought that what Jethmalani made a difference in our, I said, the history of liberty in our country. The eminent personalities, they talk about the basic structure of the Constitution. So everything about basic structure is about liberty. You can build so many dimensions and about liberty and their connection to basic structure, but I'm not going to talk about that. But I thought the more passionate engagement of Mr. Jethmalani about liberty and how he thought that's the fulcrum of the constitutional values, it's important for us today to talk about a National Institute for Criminal Justice Administration. I think about the most common women and men in our country who face the onslaughts of justice administration without those carrying hands and comforting or solace giving aid and assistance to the state. I conceive that this kind of an institution will be able to fill a huge gap in criminal justice administration. We are talking about the pendency of cases in trial courts, and we talk about the unfortunate men and women who get into prisons without seeing the day of hope as quickly as I would like to have. I look at all that very dark gray landscape which seem to be part of our criminal justice system. Why can't we think about removing the dark gray landscape and make it more brighter? And I think that's a great contribution, a commitment. As an Attorney General, I can think about, and I'll probably conclude with a few personal recollections. In 1980, he was arguing a preventive detention case. I was just about 1 year in the Supreme Court bar, sitting in the Chief Justice's court, listening to him, his stern, full, majestic voice. I could still find that ringing in my ears. It never faded away. Many of us who are with him for long know that the stern, full, majestic voice has become part of our, life in the court and chronicles, all over. In 1986, I was appearing on behalf of a very unfortunate Adivasi woman from Gujarat who was subjected to a sexual assault in police stations. One of the local legal aid organizations asked me, how do you go about this case? And they had a feeling that if you go to a local magistrate's court, sure, justice will not be done. So when I was asked, how do we go about this case, I said, let us ask the Supreme Court to intervene in a matter like this. Now, what else will liberty can mean if Supreme Court will not reach out to the rescue of such unfortunate women? We built a case on violation of 14 and 21. The Supreme Court came to our rescue and was arguing that matter in the afternoon before Chief Justice Bhagwati. Mr. Jethmalani was in the court. So after a couple of hours after about 4:30, I thought he would have left the court. But he was in the coffee house waiting for a few people to be talking to him. And then he called me inside and said, I think the one thing probably you would do good for the country is to keep liberty burning in your heart. And I think that's a great, warm advice given to me. And I think I've been able to keep that in my heart. And I'm sure that many more occasions like this where beyond passion and emotion, much more intellectual and engaged conversations and dialogues and discourses, which will probably enrich what I would probably call again the life and comfort and solace of the least or the most disadvantaged and the least cared for in our country. If justice cannot mean anything to them, I think justice does not mean anything to any one of us. So I would probably only say that Mr. Ram is probably standing by my side, as he stood by the side of Chief Justice of India, to pat him on his back, to be as passionate as possible about liberty and justice. And I think I'll continue to hear his voice by my side. I thank Mr. Jethmalani for giving this opportunity.
Thank you so much, sir. Ladies and gentlemen, he is the doyen of the bar, the legal legend, the Bhishma Pitama of the legal community. We have the distinct honor and privilege of having such a towering figure in the world of law and jurisprudence among us, a luminary whose name is synonymous with excellence and integrity in the legal field. Ladies and gentlemen, Mr. Fali Nariman is a legal titan whose illustrious career spans decades and whose contributions have left an indelible mark on the landscape of Indian law. His journey through the corridors of justice is a testament to his unwavering commitment to upholding the principles of justice, fairness, and the rule of law. As we invite Mr. Nariman for his keynote address today, we're not only welcoming a legal luminary, but also a role model and an inspiration for generations of legal practitioners and aspiring advocates. His legacy serves as a beacon of hope for those who believe in the transformative power of the law to shape a more just and equitable society. Ladies and gentlemen, we give to you Mr. Fali Sam Nariman to deliver the keynote address.
Thank you. Honorable Minister of Law and Justice, it's very good to have met you and seen you and heard you. Former Chief Justice Deepak Mishra, my friend Guru Murthy, whom I am delighted to see after so many years, but fortunately we have met each other and had a bit of gups-up whilst the speakers were on the floor. And my friend Mr. Goswami, who just delivered a very strident expose. Why not a debate? He's quite right. Of course you have a debate. Nobody must suppress any debate on any subject. And this subject is actually well worded as well. I know I'm listed to speak only on a set topic, but let me tell you frankly that I have stirred out of my home this evening principally to participate in an event. The event being the centenary celebration of not only a great advocate, but also a great maverick who was also my friend. And this is why I first crave your indulgence to pay my tribute to his memory. It was said of a famous US attorney that he was such a superb advocate that he made money on the side by selling tape recordings of his final arguments in court. Jethmalani was, by common acclaim, a superb advocate. It was a treat to see and to hear him, and those of you who didn't, is a great misfortune. Even though he never sold tape recordings of his arguments in court. Pushing 97, with his unstoppable, record-breaking 70-odd years at the bar, Ram sadly left us on 8th September 2019 after setting up, and this is very important, a high benchmark of professional excellence about which you heard the Chief Justice expound in a very brilliant memorial address. In life, one has to be fortunate in one's given name. If your name has 4 letters, like Nani, N-A-N-I, for instance, it carries you a long way, as it carried the great Nani Palkhiwala in his fascinating journey through life and the law. But if your first name is only a 3-letter word, like Ram, it may carry you even further, simply because Ram is on the lips of every God-fearing Indian morning, noon and night. It is great that his son has remembered to celebrate his 100th birth anniversary. But I have a small grievance, and I must ventilate it here. Mahesh's illustrious father, if he was with us, would have celebrated this occasion with far more aplomb, with far more panache. In the first place, he would not have planned a lecture in this hall at all. Instead, ladies and gentlemen, if I know him, and those of us who knew him, he would have hosted a party in far more salubrious surroundings, inviting you all, and served spiked beverages to all present. But alas, it's not to be. So now permit me to say a few words on the subject chosen for this memorial lecture. The basic structure doctrine is inextricably linked to what has been mentioned in one article of the Constitution, the Amendment Article 368, the only article dealing with substantive amendments to the Constitution. The constraints on constitutional amendment have been and are attempts by courts, not just in India, but around other parts of the world as well, to ensure the survival of democratic institutions and, to use the phrase of Mahesh, extremely well put, serve the nation well. Very important. Serve the nation well. In India, in the past 50 years, 1973 to 2023, the application of the doctrine has followed this particular pattern. First, the doctrine of basic structure is now established and accepted by 6 nation-states around the world: Bangladesh, Pakistan, Uganda, Israel, Malaysia, and a small country called Belize in Central America. Second, let me give you how matters stand in India between 1973, when the doctrine was first propounded, and 2023. Since 1950, we have had 105 constitutional amendment acts under Article 368, which 60 new articles were inserted in the Constitution. 17 originally enacted articles have been removed, and 154 originally enacted articles have been substituted or amended. This is not my cleverness which brings this out, not at all. It is derived from a complete list of amendments which you will find in Wikipedia. You just download Wikipedia and you will get the amendments, and you just have to look through it. Third and most important, the basic structure doctrine has been invoked so far sparingly by India's Supreme Court. As you will appreciate from the following figures, between 1973, the decision in Keshavananda, and the current year, 2023, there have been 22 reported cases in which constitutional amendments have been challenged on the basic structure doctrine, out of which in 7 reported cases, 7 in 50 years, the challenged provisions have been struck down by the Supreme Court of India by invoking the basic structure doctrine. So it is impossible to generalize. You can certainly look at any particular case and criticize it, and there a debate would be meaningful. In 15 reported cases, the challenge on the basic structure doctrine has been repelled and rejected. That is to say, the validity of the challenged constitutional amendments have been upheld by the court. Now let's go further. The striking down has always been on some principle related to what I call good judicial governance. Not interfering judicial governance, but good judicial governance. In constitutional law, especially in constitutions that prevail in all the 56 Commonwealth countries around the world, governance is by 3 organs of the state. The legislature, here parliament, in elsewhere parliament called differently, Knesset in Israel, etc., the executive and the judicial. And in matters of judicial governance, you must know that there exists a theory about its legitimacy, expounded by a renowned academic jurist of the 20th century, a man called Ronald Dworkin. He's quite famous around the world. Dworkin had said, and I mentioned this, present-day judges who may have had nothing to do with the written constitution when it was first framed, by reason of their position as judges, have become and must act like partners with the framers of the Constitution in an ongoing project, since it is and always will be an ongoing project, to interpret a historic document in the best possible light. And he went on to say, and these are his words and not mine, judges may therefore sometimes make new law, either covertly or explicitly, but when they do so, they should act as, and this is very important, when they do so, they should act as deputy to the appropriate legislature enacting the law that they suppose the legislature would enact if seized of the problem. This has since become known around the world, and you must also know this, as the Hercules technique of constitutional adjudication. Does the Herculean technique of constitutional adjudication apply in India? It does, because it is incorporated in an originally enacted Article 142 of the Constitution, an article which provides that in the exercise of its jurisdiction, the Supreme Court of India, and the Supreme Court alone, not the High Court, not the other courts, not the District Court, the Supreme Court of India may pass, and I quote from Article 142, may pass such decree or order in a case as is necessary for doing complete justice in any cause or matter pending before it. And the word complete justice in Article 142 is deliberately left undefined. It is something which, in the opinion of the Supreme Court and the Supreme Court alone, will, in the words of Mahesh Jethmalani, serve the nation well. This is important once again. Hence, for instance, and this you must remember this instance, when members of India's parliament during the period of the internal emergency, which was June 1975 to March 1977, those who were not in jail under preventive detention could not attend this session. and there were many. When members of India's parliament during this emergency had added clauses 4 and 5 to Article 368 by the Constitution 42nd Amendment Act 1976, clauses that completely precluded the court from calling in question any constitutional amendment on any ground whatever, with an added clause declaring that there shall be no limitation whatever on the constituent power of Parliament to amend by way of addition, variation or repeal the provisions of Article 368. And when this amendment was challenged, the then members of the Supreme Court, in rare unanimity, struck down clauses 4 and 5 of 368 because of its excessively overbroad formulation. The court holding that in excluding all judicial review over any constitutional amendment, there was a violation of the basic structure doctrine. Individual members of the public may from time to time get worried, I sometimes am, with orders and decisions given by individual judges of the Supreme Court. But please, never lose faith in the higher judiciary as an institution, as one of the 3 constitutional organs of good governance. As you all know, the basic structure doctrine got established initially in 1973 in Keshavananda with a very narrow majority of judges in favor, 7 judges in a bench of 13. It was held by the majority, 7-6, that the basic features of a written constitution could not be taken away by an amendment of the Constitution. But you also need to know something more, that in November 1975, a bench of 13 judges was once again reconstituted by Chief Justice Ray to reconsider the correctness of the majority view expressed in Keshavananda. And in this bench of 13 judges, there were 8 new judges, all appointed after Keshavananda, replacing those who had retired at age 65, which is the constitutional age of retirement. And this new bench of 13 judges heard arguments on 2 days of November 10th and November 11th, 1975. And on the morning of the 3rd day, 12th of November 1975, when the court of 13 judges reassembled at 11 a.m., Chief Justice Ray, presiding over the 13-judge bench, suddenly and peremptorily announced, "This bench stands dissolved." And all the judges rose and went back to their chambers. And this was only because Chief Justice Ray was satisfied that the doctrine of basic structure was not to be reconsidered by any of his 12 colleagues. And this has been recorded in a constitutional law book which is now famous, Mr. Sirvai's Constitutional Law of India, where he expressly mentions this. And please remember that he was not interested, he was not a person who had any bias. On the contrary, he was the person who had appeared for government in Keshavananda, and as making the principal argument even before the Attorney General, Mr. Nirande. This is not all. In the year 2007, the basic structure doctrine was once again questioned, and yet again a bench, this time of 9 justices, unanimously affirmed the doctrine of basic structure. But lastly, and most significantly, the basic structure doctrine, or what is known as the essential features doctrine, which is its other name, has now acquired a place of permanence in constitutional adjudication, simply because and you'd be surprised to know this, it was initiated by India's parliament itself. This is how it was done. There is an article in the Constitution, 359, which had been enacted in 1950. And it states that if during any period when a proclamation of emergency is in operation because of internal emergency or external emergency, the President of India, which in effect means the central government, is specifically empowered by order to suspend the right to move any court for the enforcement of all or any of the rights conferred by Part 3 of the Constitution, that is, all or any fundamental rights, even though in ordinary times the enforcement of all or any fundamental right is guaranteed by Article 32 of the Constitution. So also, during the period of an emergency, all proceedings in court for enforcement of fundamental rights, according to Article 369 as enacted, are to remain totally suspended for the period during which the proclamation of emergency is in force. But after the lifting of the oppressive internal emergency imposed on 25th June 1975, and after the 6th general election of March 77, India's newly constituted parliament met and expressly declared by Section 40 of the Constitution Amendment Act 1978 that the right to move any court for the enforcement of rights conferred by Articles 20 and 21 even during the period of an emergency can never be suspended. To paraphrase this in legal language, it was the considered view of India's parliament, not the view of India's higher judiciary, but of India's parliament, that the fundamental right to life and liberty in Articles 20 and 21 were a part of the basic structure of the Constitution. Because in the statement of objects and reasons for this amendment, it had been expressly stated by the then government in office that this was done in order, and I quote, to check the misuse by the executive of the emergency provision. In other words, the right to life and liberty from then onwards had, according to Parliament itself, been a part of the basic structure of the Constitution. I would like to end this intervention of mine with a wish. I wish that the basic structure doctrine continues so long as people, particularly ordinary people, choose to remember that great human rights advocate of his time, Ram Jethmalani. Thank you very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.